results program planned by the ABA Forum on Construction Law Division 1, which specializes in litigation and dispute resolution. It's co-sponsored by the membership committee of the ABA Forum on Construction Law and the Construction Litigation Committee of the ABA section of litigation. We used to go as a membership committee and forum volunteers to law schools and have this program so we could meet in person, and we'd bring pizza and show what practice of construction law is, and have a discussion with a panel that has in-house counsel members and different practice areas of construction law to introduce law students to the forum and, most importantly, the practice of construction law. And because we can't come to your law schools today, we decided to plan a virtual law school outreach program. And this program is going to have two parts. The first part is going to be a panel discussion where we have a fabulous group of 4 very experienced construction attorneys to describe what construction law is, how it's unique, why it's a good practice area to get into. And we're going to have that moderated by the forum's, ABA Forum's law student liaison, which is exciting to have a law student lead this discussion. The second part of the program is going to be a networking component where we're going to break up in 10 different breakout groups for 20 minutes. We organize those on a regional basis, so you can hopefully meet and build connections as part of this program in your area for career or for business development. It's meant for attorneys and to network with each other as well. Now I want to introduce our panel. Each of our panelists are members of Division 1 of the ABA Forum on Construction Law. And Division 1 is one of 14 divisions of the ABA Forum on Construction Law. And as I said, it specializes in litigation and dispute resolution. We'll talk more about the forum after the program, but one of the unique things about it is that we do have these 14 different groups, one of which is young lawyers, and that could be a particularly interesting opportunity for law students. Our first panelist is going to be Roy Wagner. He's a partner at Michael Best Friedrich in Milwaukee, Wisconsin. He leads his construction practice group and has been a leader in his local state bar associations. He is the Division 1 membership liaison to the membership committee. Ed Green is in-house counsel at Suez Water Technologies in New York City. He handles the day-to-day commercial operations for Suez and Suez's global dispute resolution and litigation activities. And he's Division 1's in-house counsel liaison. Third, we have Patrick McKnight. He's our newest attorney on the panel. He's 1 or 2 years out from law school. I met Patrick as a law student writing for me for the forum's publication called Under Construction. He's also on Division 1's blog editorial team that we have, and so he's been a big help to Division 1. Alex Dockery is a construction attorney at Goulston & Stores in Boston, Massachusetts. She regularly represents owners and contractors on a variety of construction projects and disputes. And finally, as I said, Lexi Pereira will moderate our panel. She's a third-year JD MBA candidate at Boston College. She grew up in the construction industry and is presently a law clerk at a large construction management company in New England. She's the forum's law student liaison, a member of Division 1's blog editorial team, and recent author of 2 editions of Under Construction articles. As we go through this today, I suggest you put the view on speaker view. That way you'll see each one of our panelists talk when they are called upon and give their responses. The first part of this program is going to be 45 minutes long, and then we'll go into our networking portion of the program. We did circulate to you about 2 or 3 hours ago, a link that has some information about the forum. We'll post that in the chat room so you can have access to that. Also, if you have any questions that you want to ask or comments, you can post those in the chat room. I'll take a look at the chat room from time to time, and if it's appropriate, I'll interject and pose a question. So with that, thank you everyone for attending this program. I'm really excited for it. It's been a lot of work to plan it. And Lexi, if you want to take away the program, thank you.
Thank you so much, Tom. It was a lot of work, and that's all thanks to you and everyone else on our planning team, like Chris, MJ, and Roy. The forum is lucky to have each of you, so thanks. Thank you also to our panelists for being here today. I'm honored to have the opportunity to moderate you all. So without further ado, let's get started. So we'll start with Roy, go to Ed, then Alex, then Patrick. Can each of you please introduce yourselves, provide a brief description of your practice, and explain how you became a construction lawyer?
Thanks, Lexi. I'll try to keep this under an hour. In any case, I've been practicing 40 years, and I have to say I put a sports coat on to make sure you knew I was the oldest guy on the screen. Secondly, I do want to tell you, law students, is that the decision to become a lawyer, the decision to become a construction lawyer, and the decision to become a member of the forum were some of the best decisions I've ever made, besides marrying my wife. And it's a practice that every day, even at my age and my stage of my career, I love going to work every day. It's always different. It's always unique. And one of the things I've found, and one of my mission statements will be here, is get involved in the forum early, because I got involved late and actually realized I wish I had and joined earlier. So it's a great profession, a lot of variety. My firm has 14 offices across the country. My practice consists of what I call general construction. I work with all the different elements, and it's a very vertical industry. I'll talk about that later. And again, the dynamics of construction will make it a career first choice for you as well. Thanks.
Hi, yes. My name's Edward Green. I'm a 2001 graduate of Boston College Law School. I initially did not start out as a construction lawyer. I actually started out as a securities M&A lawyer in one of the bigger New York firms. So my journey to construction law was kind of a trial and error of finding what the things that I like, or the things that I like to do, or the ways I would like to practice law. Eventually, construction is kind of where I found my home. I do wish that I had gotten involved with the forum earlier. Luckily, I met up with Tom later, who's kind of kept me in there. I'm kind of here to also let you know that the path that your career takes, you guys are all going to graduate in kind of a more tumultuous time, it being, COVID-19 and all. And that could be to your benefit, as it kind of was to mine in the career, graduating in 01, literally starting work the day after 9/11 in New York. It's not something to be scared of. So, hopefully construction is a place where you want to concentrate your efforts, because it is very multifaceted.
Hi, I'm Alex Dockery. Like Ed, I graduated from law school during a somewhat tumultuous time, the last Great Recession. And so I think a common theme is I didn't start out as a construction attorney. I found my way here on a sort of what felt at the time like a long and circuitous path, but it certainly was a fortuitous path for me. And so I have sort of run the gamut of representing contractors, owners, some designers, though not that frequently. And my practice has really spanned all aspects of the construction industry. I've done industrial work, power work, I've done vertical construction work, I've done infrastructure work. And that's one of the things that's so great about construction law is it's such a diverse practice. It's such a breadth of clients. And the work is really interesting and varied. And so you can really build a career in any way you want, doing a variety of different types of representation. And, I think for law students graduating in an uncertain time, it's great to have an idea of what you want to do. But I also just want to put a plug in for sort of seeing where the climate takes you, seeing where you can build your skills that will be later transferable and get you to that end game, to that goal, even if it takes a little bit longer than you thought it might.
Hey, my name is Patrick McKnight. I am a Rutgers University JD MBA. I am a brand new lawyer. I'm an associate at Claire Harrison in Philadelphia. I work in the commercial litigation department, but I spend a lot of my time on construction matters. I got involved as a law student in this forum. I was clerking at a firm. My team focused heavily on construction. I really enjoyed it. That led me to this forum. I started writing. Tom and the other members were very kind in encouraging me and publishing my work. And now I'm an editor on our blog and I'm loving it. And I really enjoy this area of practice. And I think that in particular, this forum has a lot of resources available for law students. And I really encourage everyone to take advantage of those.
Thank you all. Up next, Ed and Roy. Of course, we just heard from all our panelists as to how and why sort of they became construction lawyers. Can each of you, first Ed, then Roy, tell us what's so unique about construction law and what you really enjoy about it?
Yeah, I guess I'll start. Construction law truthfully is kind of a unique aspect, area of law. The reason that I primarily chose to focus here is because, like I said, graduating in 2001, I focused on corporate and M&A work, which dried up very quickly after 9/11, then kind of transferred into more kind of regulatory enforcement, internal investigations, commercial litigation, because that's what was kind of hot at the time. I find that construction work is very multifaceted in the fact that you are on the deal making aspect end of things when you're kind of negotiating different construction contracts and agreements with clients, or you're kind of counseling your client or your in-house client on aspects of the deal, and you stay involved all the way through interpretation of the contract throughout the project, or kind of even ghost letter writing, which happens a lot with clients. And then you're also involved in project closeout, because these days it kind of inevitably a lot of times ends in dispute resolution, which is kind of what this forum is about. I mean, unfortunately, the idea of construction and infrastructure law these days is a lot about dispute resolution at the end of contracts. And then there's always claims and management at the end. So you're kind of way more of a business partner than you are in other aspects of law, where you're kind of just counseled once a project, when something there's an issue a lot of times, or you're just kind of on the front end with making the deal and you don't kind of own that baby throughout. So that's the main thing I like about it. But I also like how you meet the breadth of people that aren't just, in my prior life, it was kind of working for big banks, and I never really saw the fruit of my labors. It was kind of, I like to say, soulless law. Whereas now, the clients you can have as a construction lawyer can be from, very small regional subcontractors who have a lot at stake on very sophisticated projects, to kind of the big boys, the Burns and McDonnell's, AECOMs, Kiewitz of the world, and it gives, and you'll meet blue collar people, you'll meet varying different types of personality. To me, it's a lot more exciting than anything that I saw in my past practice.
Yeah, to follow that up, Ed, what I would say is that, in a lot of law firms, you'll have transactional lawyers who are just contract lawyers. They don't want to get out of the office. You can do that in construction law. If you don't want to be a litigator or the like, I got into it because I like litigation, I like the claims, and I came to understand that a lot of litigators were what I call homeless lawyers. They had to get work from their business partners. I like the fact that when I was a litigator, I had built-in clients in an industry that I knew was, quite frankly, conflict-driven, or I don't want to say litigious, but there's certainly claims right. And so the idea that you could do a contract, understand it, take it through litigation, and understand the dynamics, I think was really important. And you're a better advocate for that contractor as well. It's a broad practice. You can have administrative stuff, contract stuff. You can be related to all sorts of torts and remedies. One thing I really didn't count on, but you're going to get to know insurance law. Insurance is very, very important in construction, and most of it you can learn by osmosis as well. I think understanding your client's business is really important. And by that, I mean accounting, business trends, the types of insurance issues they face, the economy in general. You want to be their partner and understand the dynamics and what makes them work, OSHA violations. And I like construction lawsuits, but what's really fun for me is a lot of my contractors will call me in the middle of a project and say, hey, I got this going on. And I call that working on a live patient. And I've had multi-million-dollar claims where I have been behind the curtain all the time, just ghostwriting emails, ghostwriting letters. And to be honest with you, that's much more fulfilling than showing off my stationery or trying to, stick out my chest more than the next guy to get a result. It's much more gratifying. And secondly, because it's a very vertical industry, it's a lot different than like personal injury or employment law, where you're either plaintiffs or defendants, employer or management. It's a very vertical industry because you got owners, general contractors, construction managers, architects, and then subcontractors and suppliers. And one day I'm at the top looking down, the other day I'm at the bottom looking up, or somewhere in between. And it's nice to be able to explain to those different levels of the construction industry, hey, you may want that, but you'll never get it. And you'll say, why? Well, I represent contractors and they're not going to agree to that. So I like that fact. It's a very puzzle-driven business that has a lot of different dynamics, and you can really do a lot of good. So that's what makes me feel good about it. And I think that's what's unique about construction practice, Lexi.
What I know about it so far, I definitely would echo all that you guys said. Of course, we just heard about how great construction law is, how it's broad and it's an exciting practice. Patrick, can you take us through what a day in the life of a construction law associate like you, a year or two out of law school, does?
Well, I think it's pretty safe to say that you'll be doing a lot of document review early on in your career, because construction law is very document intensive. So for example, right now I'm working on a case where we have something like 100,000 documents to get through by the end of the year. And you might be doing that the old fashioned way with a room full of banker's boxes full of documents, or you might be doing that on a platform like Relativity, which is the more modern method. But either way, you're going to be getting your hands dirty with the facts of the case. And although it might not seem very exciting, you can make yourself very valuable to your team, because I can promise you the partners aren't reading those 100,000 documents, you are. So you might end up knowing the facts of the case better than anyone else in your firm, which makes you a very important person. On the other hand, you might actually be doing site visits. You might be getting out of the office and observing a demolition taking place or something like that. So depending on the firm, you might be drafting motions. You'll definitely be doing research assignments, legal research and writing, which is going to be essential to your success as a young lawyer. But overall, I think construction law in particular gives you a lot of opportunities as a young lawyer to make a contribution right away. So that's one of the things I really enjoy about it.
Awesome. Alex, we've heard that one of the items that's unique about construction law is that many attorneys get to represent all the different parties involved in construction, including owners, subcontractors, general contractors, design professionals. Can you please explain for us that dynamic and your strategy as far as litigating and engaging in the ADR practices change?
So, I think in general, and this is good advice, whether you are a construction lawyer or not, but the most important piece of being able to provide the appropriate service for your client is understanding your client, understanding their goals and their needs. And so in construction, we have the opportunity to really learn about the business of our clients in a way that often other litigators don't. But an owner versus a supplier are going to have different goals with respect to a dispute or a litigation, and they may have different appetite for going head to head with a sort of scorched earth litigation strategy versus looking towards an early settlement or resolution. Subcontractors may have concerns about maintaining ongoing business relationships with general contractors who they work with a lot, or even owners who have multiple projects or multiple developments. And so that piece of information is going to factor into whatever litigation strategy they're going to want to pursue, or whatever litigation strategy might be most appropriate. Owners may have concerns about lenders or investors. They may have a vested interest in making sure that the property remains free and clear from mechanics liens. And so at its heart, what you need to understand is what works best for your client in terms of their goals. Are they able to go for the years it may take to resolve a litigation without obtaining the funds that are in dispute? Will they be able to pay for the costs that come along with alternative dispute resolution? ADR, this is something we'll talk about. Arbitration, for example, sometimes it can be faster than a state or federal court case, but it comes with costs. The arbitrators have to be paid. The various organizations that administer these arbitrations have fees, and oftentimes it's more expensive in that respect than filing a court case. And so you need to know from your client, what is their goal? And that way you can develop a strategy that best meets their business goals, their expectations, and the facts of the case.
Thanks, Alex. Roy, Alex just mentioned that we need to meet the needs of our clients, which can sometimes include engaging in ADR, or alternative dispute resolution, such as mediators, arbitrators, and other forms in construction law. Can you please describe for us those and describe how your advocacy style changes when you represent different clients in those venues? Roy, you're muted.
Clients are obviously looking for expert lawyers, but at the same time, they're a little bit concerned about having what I call generalist judges or generalist juries. They're concerned when they have to explain what an RFI is, or request for information. So the construction industry is very much in sync with the idea that if they have a dispute, they want those that are in the room deciding it, both their lawyers and the neutrals, which is like a judge or a mediator or an arbitrator, have some construction background and experience. So you'll see a high prevalence in the construction documents where they will refer to arbitration, and many times to arbitration bodies that have construction experience or construction neutrals. Obviously, the difference is mediation is an attempt to hire somebody who has a private experience. Usually they've served in the construction industry in some format. I'm asked to be a neutral quite a bit because of my years of experience. The idea being that it can be faster. It doesn't mean they're going to get their way. It just means sometimes we lop off some of the uncertainty that might happen at the end of the spectrum. Arbitration is essentially a private trial. Again, you're hiring a neutral. It has the ability to cost less, but not always. Arbitration is getting very bloated, and a lot of people are concerned about that. So there's been spin-offs of arbitration in ways to try to reduce the cost of that. But your job as an advocate, I don't think changes all that much. You're still there in each one of those formats, whether it's civil litigation of public court, arbitration of private arbitration, or mediation, is to present your case. I'm a big fan that I like, visual cases. I like cases that I can explain. If I have a choice, I'd rather have a 1 or 2 issue case versus a 15 issue case, because it's always easier to get across to your neutral when that happens. The bane of my practice right now is text messages. I hate them with a passion because they're hard to present, and quite frankly, we're having change orders and all sorts of contract documents, modified by that. So dispute resolution is an important process, and I think, quite frankly, it's reduced the amount of public trials by a significant amount. Most of them ending up with private mediations, obviously, and private arbitrations. Lexi.
Thanks, Roy. And Lexi, I'll just jump in really quick here. I mean, it's the thing about arbitration that's so fascinating is that it really depends on the panelists that you get to serve as your neutral. So sometimes it can be run super efficiently. Other times it looks a lot and feels like litigation. So it is a big decision when you pick your neutral. That's a major part of the arbitration process. One question I have for the panel, and whoever wants to jump in on this, please go ahead, is I'd like to hear your thoughts on the business case for the practice of construction law and practicing in the construction industry. In particular, we're going through a cycle now where it's another economic downturn, and is construction law an area that can be recession proof in some aspects. And then as part of that question, if you could give a sense of what qualities, if you're involved in hiring at your law firms or your companies, what do you look for in a construction associate? Ed, do you want to talk about the business side?
Yeah, I wanted to make a comment from like the in-house side. I mean, I really can't kind of comment on what we look for an in-house associate, although I would like this for an in-house attorney. But I would like to say that unlike when I graduated, there are kind of opportunities for new law graduates to kind of go in-house, whereas before that was kind of unheard of. Tom, if you don't mind, repeat part of your question there.
I was just curious, you're embedded in
Oh,
the
the business
industry.
case. Sorry.
Ed, and-
Yeah, the business case. Well,
Yeah.
like for instance, from my particular standpoint, I work for a large water services company, and we're kind of all over the place on the spectrum. Sometimes we're the owner, we do P3s, build, own, operates. Sometimes we're small specialty subcontractors. But the one thing I can tell you is the kind of services that we do, and this is kind of general for the whole construction industry, are essential. While they can be put off, they can't be canceled. So while, like, for instance, this particular crisis might be causing a lot of our projects to be kind of delayed, at the end of the day, they're kind of needed for society to go along. I mean, I think the biggest threat that we have to kind of being construction lawyers are probably AI and blockchain technologies, more so than it's a lack of work that will come, because our services will also be needed. But I also like the fact that during, better economic times, what you generally have is more deal making and easier goings in kind of your dispute resolution procedures, where fights might not be as contentious and owners are a lot more likely to be a little more loose with the purse, rather than you have times like now, where now all of a sudden dispute resolution, change order provisions are going to be a lot more debated and contentious, and and it's kind of the ebb and flow varies more so than I would say you kind of lose or lack work. Whereas I've been on the M&A aspects or corporate aspects of deal making, and kind of like what was said earlier, one aspect of a law firm, the corporate and litigation parts, will depend on the other to feed business, and we're not really beholden to that. It's kind of always there.
I think that ebb and flow also on the business side feeds into what, as an attorney, sort of provides, as an outside counsel, provides job security, right? So when business is booming, when the economy is good, because construction law is a holistic practice, we're there, we're helping to do the deals. When the economy is constricting, if there's a crisis like COVID-19, the construction attorneys are there on the front lines, helping to put claims together, helping and advising with respect to force majeure notices and any sort of other notifications, helping with OSHA investigations, helping to navigate implementing new CDC guidelines to make sure our clients are in compliance when they do go back to work. And so I think, Tom, maybe that's sort of what you're getting at with respect to things being recession-proof is, unlike many other practices, because we help the clients from start to finish, we're there in the times where perhaps things are testier, but there's more disputes because there's less to go around. But we're also there when times are good, helping with the deals and putting things together that maybe down the road we may end up having to litigate or have a dispute about.
Yeah, and one thing about construction services in a lot of states were considered an essential service during the, shutdown of, March and April and May. And so, that was crazy to go through, but the construction operations, particularly public works, continued and didn't slow down. Rory, we had one question about, and you talked about arbitration. Can you just describe briefly about how you select the arbitrators in an arbitration process?
Sure, Tom. The parties can pick whoever they want in essence. And usually it starts in the contract with, oftentimes they'll provide an arbitral body, which can supply the neutrals. And then in the case of the AAA, you would say you get a AAA roster, and then you would strike from there and select from there. But even when you do get a AAA roster, you have the right to, just select whoever you want if the parties are so agreeable. And there's a lot of ad hoc arbitration that goes on where, parties have a dispute and they just can't agree on a neutral. And so again, it's part of the agreement, but if the agreement just says AAA arbitration and nobody can agree, that the AAA will take the process through and you'll be assigned somebody rather than having an impasse.
Thanks for that, Roy, and thank you, Jordan, for selecting that good question. Moving on, we are going to see if Ed and Roy could both give us some quick suggestions on or ideas on how exactly you go about drafting a dispute resolution clause in the contract. Ed, why don't you start first? You're muted, Ed.
Sorry about that. I think we kind of may have skipped a question that I kind of wanted to touch on, which was, you know, kind of international arbitration versus domestic arbitration. International arbitration, I work for an international company, and, you know, some of the key differences, you know, in the States, we have a much more litigious or claims ridden society than a lot of other ones. That leads a lot of it. And then the other phenomenon you see these days is there's a lot of foreign companies, such as like Daragos and Iberdrola, that are kind of coming in and taking stakes in local infrastructure and construction companies in the States, who may not necessarily be used to kind of our ADR procedures and how we manage our claims. You know, our Rule 26, like for instance, our federal claims, you know, our Rule 26 discovery rules are a lot more thorough than what you'd find in international arbitration. So a lot of times, at least for my practice, you know, forum selections about where you're going to arbitrate internationally and making the other sides kind of comfortable with the fact that if disputes arise, there will kind of be an enforceable and fair judgment is kind of more crucial. As far as drafting ADR clauses, one of the things that I like to do as an in-house counsel is look at, you know, how we can avoid and deal with disputes outside of just purely the ADR clause. So for instance, things like the change order provisions, you know, when I'm a sub, I like to know that if I'm going to hit with liquidated damages, that the owner is going to have to show kind of demonstrable delay on the critical path. You know, liquidated damages clauses and the difference between those, between, you know, municipalities and even countries. You know, in states, they can't be penalties, and in foreign jurisdictions, they actually have to be penalties. That's one of the, you know, such as Canada, that's one of the differences. Let's see what else about ADR. You know, you kind of have to realize when it comes to these projects, it's more of a zero-sum game. You know, at the end of the day, there's not an infinite amount of money to go around, and there are going to come in disputes on these at the end, and kind of questions as to you know, how we're going to pay out and how those funds are going to be distributed, you know, between the subcontractors and different contractors. I'll let Roy kind of take it from here.
Yeah, thanks, Ed. I think the first conversation I have with my clients is, have you had any experience in court or in a arbitration? And usually that colors their decision-making as to whether or not they want to have litigation in a public courtroom versus a private arbitration after that. So that's usually the first decision tree. Then the second is, if it's going to be arbitration, do you want to suggest an arbitral body like the AAA, JAMS, or one of the other groups that offers arbitration, or go ad hoc, which essentially means, you know, find somebody. In our state, we are required to designate a set of arbitration rules in order to have the arbitration clause to be enforced. The other dynamic I discuss with clients as a cousin of this issue is fee shifting. In the event of a dispute, who gets attorney's fees, if anybody? You know, as law students, the American rule says that, you know, each party bears their own attorney's fees unless it's provided by statute or provided by contract typically. And so we talk about that dynamic. You know, one of the things that, you know, Ed faces being a contractor or supplier in the middle is usually the person upstream, the person with the money, has the leverage. And so they oftentimes have the ability to dictate these terms, because if you want the job, you're going to agree to my contract, and my contract has this dispute process. So you need to understand that dynamic and be able to explain to your client what they're signing up for and what they should do as part of their decision tree. And so just on making sure that your client understands that, but a lot of their decision will be colored by their past experience, you know, with litigation or arbitration.
So we had a few questions come in. Thank you for those responses, Ed and Roy. The questions are that, you know, do most construction attorneys that handle litigation also do arbitration? And then as a follow-on question, how important is it to have a technical background and experience, whether in engineering or architecture or construction? Is it for a construction attorney to have? And how, in the cases that you work on, do you work on with experts to obtain that technical experience for the various matters you have? Alex, do you want to chime in on those?
Sure. So I think the thing that's important is, let me say, I do not have a technical background. I'm not an engineer. My major was sociology in undergrad. So you absolutely can be a successful construction attorney without an engineering background. That said, I think especially when you're a junior, it can be useful to speak the language, to understand the sort of general ideas about construction sequencing, the trades you're representing, and sort of how the project that you're working on comes together. One thing that I know that the forum offers is a program called Sticks and Bricks, which can be a really useful, I'm not sure the next time it's going to be offered, but it can be a really useful resource if you're just starting out or if you don't have an in-depth background in construction work, to learn the vocabulary, to understand what goes on a job site. How does the change order process work? What is an RFI? How does it work? When does it come in? What is the sort of standard approval process for things? How does a scope of work get developed? So I would really recommend that to everyone, but I will say you don't have to have that expertise, but and you'll learn it as you practice, but if you don't have it, and especially if you're working on a complicated project, obviously it's important to be able to find an expert that you trust, that does have the expertise, that can help guide you. And for me, I've found that it's useful to try to get those people on board early in the process so that they can help guide your litigation strategy, right? So you have somebody who understands the technical aspects of what was going on the job. Oftentimes you'll have a claims consultant, or the client will have a claims consultant that they've already hired that's helping them during the project. And so that person can serve as a resource for you as the attorney to try to give you an idea of what was going on from a more technical aspect and help you form your litigation strategy. And then just with respect to litigation and arbitration, I sort of view those things as the same, right? So arbitration is litigation. And I think most attorneys who practice construction law, and frankly, anyone who litigates commercial contracts, does both court litigation and alternative dispute resolution arbitration, because it's very, very common, especially with your more sophisticated clients, with your bigger, higher dollar value, particularly clients who are concerned about confidentiality or privacy or reputational concerns. A lot of times those clients select arbitration. And so it's if you litigate, I would say in 2020, chances are you do arbitration.
Thanks, Alex. And Rory, I got asked another question that's I'm gonna build it off the technical background and experience becoming a construction lawyer. Given your 40 years of experience, I'm in the head of the construction group at your law firm. I imagine you're involved in hiring decisions. What qualities or characteristics do you look for in law students or young attorneys when you hire a new construction associate at your firm?
Yeah, thank you, Tom. Like Alex and everybody here, I didn't have any construction background. I got my first experience because I defended architects in E&O malpractice actions. And so I got educated on that time. But typically, as I'm looking at young lawyers as to whether or not we're going to hire them or I think they're going to be successful, it's really, I think, it's one of those practices where I tell all lawyers, if you're going to be a lawyer and you really want to like what you do, you got to like the business and the industry that you work with. And I think what's critical to work with construction, you have to be a visual learner. You have to be somebody who appreciates and understands that. You have to have, some level of understanding, in sort of the physical dynamics of how things work. That's helpful. But are they necessary? No, I think you just have to have an aptitude for that, because I think most of us went to school on our clients' cases and experience, and that's how we built up our institutional knowledge. But if somebody has a background, for instance, like Lexi said, she came from a construction family, that means she's probably got a leg up on the vocabulary, the understanding of the industry and some of the dynamics. That would be positive, but it wouldn't be a deal breaker for me. So I don't want anybody out there to think that, hey, I didn't work for Lexi's family construction company, that I'm not going to get hired, because there's a lot more that goes into it than that.
Thanks, Roy. Yes, I would say most people definitely don't have the experience or plan to go into it, because people look at me like I have 3 heads when I say I want to be a construction lawyer. Anyway, I guess we will just get back to Alex and Roy. If you could both please describe for us 1 or 2 interesting projects you've worked on recently that sort of paint the picture of what it's like to be a construction lawyer. I think that'd be helpful. Roy, do you want to go first?
Sure. When we had our rehearsal, you didn't insert the word recently, so my example's not recent, but I think it's interesting. We built a $400 million professional baseball stadium here, and tragically, during the construction, there was a crane collapse while they were lifting a portion of the retractable roof, and 3 people died. I spent 3 years on a commercial claim because my client was a steel erector and was looking to get paid, and there was a lot of finger pointing going on. My opponent was employees all from a company that was, they were not English speaking as well. So all of my depositions were through translators. And so they would take hours and hours and hours to take those depositions, because I would make my question, the translator would speak it in their language, then the reverse would happen, and it would just take so much time. Eventually my adversary came to me and he said, "You're taking too long in these depositions." And I said, well, it's a time-consuming process. Well, the part that I always love to tell, and why it's interesting and would be for a law student, is when we got to our arbitration, all of those foreign-speaking nationals suddenly spoke the Queen's English at my hearing. And of course, I had been sandbagged because of that. But the other part of that is that the arbitration was not cheap. We spent over $300,000 on arbitrators, and that was about 15 years ago. So 2 lessons is that a lot of interesting things can happen even on big cases that make them novel and interesting. And arbitration is not cheap by definition, but it can be if it's efficiently worked. And you as a lawyer have an opportunity to make those rules so it can be less expensive as you're working on it. So I'd hand it over then to Alex to share her case now.
So, I was trying to think about what the best case was to share here with a good takeaway for law students, but I think the case that I've worked on most recently that I sort of feel the most excited about is, it was about a year ago now, but I was working in arbitration, international rules, international client, local dispute. And I've done a fair amount of energy generation work. I've worked on a couple of power plants, and it just so happened that in this arbitration, we were across the table opposing counsel from someone I consider to be my professional mentor. And so I did my first trial level cross-examination against the person that I really think taught me how to be a lawyer. I went to my very first arbitration with him as a junior lawyer, and I watched him and I supported him and I pulled documents and I worked all night, and it was really hard and really challenging. And at the end of it, I felt like I hadn't slept in 100 years. And then fast forward a number of years later, he and I are sitting across the table. I am the examining attorney. I'm using the lessons that I learned from watching him while I was doing that supporting role, pulling documents, making copies, doing all of the stuff that feels thankless. And we faced off. And at the end of the day, he called me and he said, "I'm proud of you. I'm really impressed by you." And that was a moment for me that was really exciting. And what I took away from it, and what I think is a really good thing, an important thing to remember when you're first starting out, is when you are a junior lawyer, you do a lot of stuff that feels really thankless, and a lot of stuff that feels like, I went to law school for this, but you should capitalize on those opportunities. You should take the chance to observe the people who you're working with. And if they are kind enough to share their wisdom with you about their techniques, about why they're asking certain questions or why they're doing certain things, take that and you'll be able to use it going down the road. And that's really, we're not like doctors. We don't get this professional experience as part of our education. You have to learn how to lawyer once you're already a lawyer, and it can be very overwhelming. And so, it's really a great opportunity. Take every opportunity as a learning experience, and you'll be surprised one day you'll wake up and realize, oh, now you're the lawyer, now you're the grown-up in the room, and you've got these skills you didn't even know you had.
That's a great message.
I certainly feel lucky that you got to be one of those lawyers that taught me along the way so far, Alex. So now we're going to pivot a bit and talk about the Forum on Construction Law. So for those of you who don't know, or perhaps not members, the Forum is designed to help construction lawyers and law students interested in the practice develop the successful traits that Roy, Alex, Ed, and Patrick all described. In fact, the Forum's tagline is building the best construction lawyers. And for me, at least, I'm already seeing that come to life through programs like this one. So if Patrick could please share what you like best about the Forum and tell law students or recent grads who are here on the call how they can best engage in the Forum like you did so as to prepare for a career in construction law.
Well, what I did was take full advantage of the writing opportunities, because I actually enjoy writing, but whether you enjoy it or not, it's going to be a big part of your profession. And I think, I was basically spamming Tom for a couple of years there, sending him pitches and articles, and he was very kind to publish them. And while I was in law school, I was a member. Membership is free, so no one has a reason not to join you. You have nothing to lose and everything to gain. That writing experience also forces you to do legal research and forces you to educate yourself about different areas of construction law that you are most likely not exposed to as a student. So you build up your experience as well. And then when it came time for me to apply for jobs, I'm very confident in the fact that my CV and my writing resume made me a more attractive candidate to my firm. Seeing that I had already published articles on construction law issues, that's something most law students don't do. That's something most people don't do until they get into the field. So I think that that's an opportunity that's out there for everyone if you want to do it. But you have to be motivated, you have to be disciplined to hit your deadlines on top of your schoolwork and everything else that you do. But I think this forum is a tremendous resource, and I know that I feel like I took full advantage of it, and I'm excited to remain involved. And I think you can also use it for networking. Networking is very important, especially as you're finishing your law school career. Finding those connections, finding those mentors. This is a great way to do it, because it's difficult, especially now in this COVID environment. In-person meetings just aren't happening. So you have to put yourself in the best possible position to succeed, and you have to be your own advocate for your own career. And I think getting involved with this forum is the best possible way to start.
I agree, Patrick. In fact, I am also involved in the writing opportunities available in the forum. Alex and I are currently writing an article on emerging COVID safety technologies that we will be publishing in the Dispute Resolver blog, which is through D1. Alex, can you please speak about our article a little bit and elaborate on the current or upcoming trends in construction law that law students and construction lawyers alike should be on the lookout for?
Sure. So Lexi and I are working together on an article about really things that we can advise our clients on with respect to how to keep the worksite safe in this global pandemic. And so a lot of the things we've been looking at are some of the sort of big flashy technologies you've probably heard about, things like Spot the Dog being used for as-built assessments and other sort of site inspection activities, which used to be done by people in order to try to limit the amount of people on site, things like that. There's other technology such as wearable sensors and other sort of self-cleaning mechanisms you may see. There are these surfaces that self-clean that try to mitigate the impact of virus transmission from, high-touch surfaces. And so there's just a number of issues, and it's not just safety, although that is what Lexi and I are focusing on because there is a breadth of impact. But I think law students would be well served now because it is emerging. And so everyone is sort of on a level playing field to take a look at COVID and the pandemic and think about ways that that is going to change, not just workplace safety, but construction practice in general. This is new. No one has done it before. And so as a young lawyer, it can feel like, well, everybody knows this already. How can I contribute something? But now we're in this really unique situation where everyone is sort of starting from scratch. And so it's a real opportunity for you to dig in as a law student, do some research, and educate yourself about innovative solutions that are coming to the fore, and you could publish on something that no one has published on before because it's such a new occurrence.
Just Alex, just butt in for a second. Will your article be addressing privacy concerns that come with also the emerging technologies and screenings that are happening because of COVID-19? Because I know in my practice, that and the GDPR are very big issues, around privacy and the information that's being asked and disclosed when going on to sites.
So that's certainly something that we're seeing in my practice at Goulston quite a bit, is people are really concerned about the interplay of the safety regulations with the sort of HIPAA, GDPR, privacy considerations, data collection. And so that's something that Lexi and I will certainly be advising on, although I will confess I'm not a privacy attorney, but it's absolutely something that we'll be raising. And I agree, it's something that the clients are raising quite frequently because it is a very challenging interplay between collecting the right amount of data to be able to demonstrate that you are maintaining a safe job site while also adhering to the rules with respect to HIPAA and all of those other privacy laws and regulations, particularly in places like Europe, where the GDPR is obviously much more stringent than the privacy laws we have here in the United States.
That's great. Well, we are edging towards the end here, but Ed and Roy, if you guys would like to just chime in, maybe speak quickly on how COVID's affecting your practice or any final remarks to close out the panel today.
Yeah, I think the last thing I'd say is, of course, in construction defect claims and the like, we used to look for the blueprints and look through the documents, and now this is all digital. And obviously we're having drone flybys and the like. So I suspect the litigation of the future will be much more driven for what you can find in the different versions of Procore and PlanGrid as construction projects evolve to see what's happening. I had one partner who sent me an entrepreneur who wanted to take a drone flyby that of the project every day to show practice. And I said, there may be some contractors and architects that don't want to have a photographic record of what they didn't do on time or what they didn't do correctly. So that could be a two-edged sword in that as well. So I think in the claims process, we're going to see a lot more digital Sherlock Holmes and evidence that's going to be done. So I think that's a trend that I'm forecasting.
To go back to one of Tom's earlier points, one of the trends I'm seeing is just like, to his earlier point about construction practice being recession proof, the dynamics of my practice have changed. It's now a lot more force majeure letters and issues, a lot more privacy concerns, on-site concerns, letters to, critical infrastructure worker exemption letters to, bypass state restrictions and different various other national restrictions. The other thing that I kind of see over time is that we are, and I think I've said this earlier, bidding jobs from a commercial point of view and making your profit margins by straight bidding is becoming more and more rare. A lot of companies and a lot of outfits are kind of looking towards the change order and dispute process to kind of realize the margins that they are looking for. And this kind of causes our roles in these projects to be kind of more crucial at this time. It also kind of will probably feed the demand for more in-house counsel as approaching, whenever I have to hire one of these guys, to kind of afford my claim, it's going to get expensive. And to the degree that you have those skill sets to kind of advance these in-house and kind of do the ghostwriting and to be, someone who comes involved in these claims earlier on, the better for, companies. So I do see us relying more on getting people, or less on outside counsel and more on kind of going in-house to kind of fulfill these needs and roles. So that's another thing that I see.
That's exciting. Thank you, Ed, Roy, Alex, Patrick. Really good job. In a normal setting, we'd give you all a big round of applause, but you just get my quiet one here. Thank you so much. Now we are going to transition into the networking portion of the event, and I'll hand it off to Tom to give us the heads up on that.
Okay, thank you. Hopefully you can all see my screen. This is the link of what we sent you earlier today. This has a bunch of information that you should go check out, particularly look at the list of the divisions that is on here. It has each of the division chair, including myself. I'm the chair of Division 1, Litigation and Dispute Resolution. And the Forum 101 program has a great PowerPoint that talks about the forum and how to get more involved. So I highly recommend that resource. You can contact me. I'm Tom Dunn. I'm a partner at Pierce Atwood that offices out of Providence, Rhode Island and Boston, Massachusetts. I'm happy to answer any questions about the forum. I love to get new people involved, law students, young lawyers, old lawyers, whoever is interested in the forum. We love to make a home for you and build our community. You'll see that we're not only the best construction lawyers out there, but we're also the most collegial and friendly attorneys. So along those lines, we wanted to have some more closer interaction during this program. So we are going to enter into 10 different breakout rooms. Each room has a discussion leader, and they're going to have you introduce themselves and guide the discussion. It's going to be 20 minutes. So we're going to go into that now. Tamara,